We have seen a 100% increase in the number of will dispute inquiries in the last 5 years. We expect to see this increase further as the economy changes. Many people we speak to are keen to understand how they can avoid family disputes when someone dies. A valid will in writing and signed by the person making the will in the presence of 2 or more witnesses at the same time should be the answer. But even where the will has been properly executed and is a valid legal document on the face of it, it can be disputed for other reasons. One issue that we often see is that the testator did not have capacity to make a will. Increasingly, people are living longer and suffering with conditions such as dementia. The presence of such a condition does not necessarily mean that someone does not have capacity to make a will, but it might give rise to a question of capacity, and people with such a condition should consider obtaining a medical report at the time of making the will, confirming their capacity. But what if you have concerns that your loved one made a will and may not have had capacity at the time? It is usually necessary to look at the file prepared by the will drafter, medical records, and to obtain statements from people who knew the testator well and may be able to give further evidence as to whether or not they had capacity at the time. The legal test for capacity says that the person making the will must have understood the nature of the will and its effect. They must also have had some idea of the extent of the property which they were giving away under the will, and that they were aware of anyone who might normally be expected to have been provided for. Finally, they must be free from any delusion of the mind that would have given them false reasons not to benefit particular people. Capacity is not always clear. For example, when recently dealing with a case, it appeared that the testator had capacity until we noticed errors in the instructions to the will drafter. She had stated that her house was previously owned by her second husband, when in reality she had always owned the house and never had a second husband. You may well have concerns that a loved one was put under duress or unduly influenced by another party to leave their estate in a certain way. Influence in itself will not be sufficient to bring a claim, and so it can often be quite difficult to prove that there has been duress or undue influence. It is important in such circumstances that as much evidence as possible is obtained, including detailed witness evidence. There are other reasons why a claim might be brought. For example, where someone's eyesight is poor, so they may not have been able to read what they have signed, where forgery has occurred, or where someone has got married without the will specifically contemplating a marriage to that particular individual. If you do wish to dispute a will, it is important to obtain legal advice as soon as possible to gather as much evidence as possible. It is also important to consider urgently entering a caveat at the probate registry. This will stop a grant of probate from being issued and ensure that the estate cannot be distributed before your claim is brought.